Thanks very much. As was said, I am now the Executive Director of Her Justice, and in that capacity, I oversee an agency that, as was said, provides legal services and advice to over 7,000 women and children in New York City every year. And one of the ways in which we do that is through pro bono service. The majority of the full representation we offer our clients is through the volunteer assistance of attorneys from firms from throughout the city. And we practice in the areas of family, matrimonial, and immigration law. One of the reasons we created this presentation for you this morning is because when we talk to a lot of our pro bono attorneys, especially externs for mid-level associates who work with us for 4 to 6 months in the office, what we heard from them was that we provide great training on the substantive area of law, and they certainly know how to prepare to litigate. But what they needed more help with was sort of the verb lawyering. How do you perform in family court? What is the judge thinking? How do I get my issues across to the judge? How do I negotiate with opposing counsel? So that's what we're really going to try to talk about this morning, to give you more comfort when you're going into family court to practice about how proceedings will go, to the extent that that is predictable. So I am joined up here today by one of our staff attorneys, Senior Staff Attorney Diane Finiello, who joined Her Justice in 2010 and is an expert in family and matrimonial law, and in addition to her own cases, supervises and mentors the volunteer attorneys that I mentioned. And of course, our guest appearance today is by Judge Segal. Phillip Segal has spent 10 years on the family court bench in New York City. Prior to that, he was a legal services attorney, and he is currently practicing in many areas, including in family law. But rather than give a long introduction, because for Judge Segal it would be long, I would like to start by asking him to tell us a little bit about his professional background.
Well, it's only long because I'm so old, but I'm actually a product of the 60s, and I went to law school to be a legal services lawyer. And fortunately, I marched out of law school, and I immediately got a job at Bronx Legal Services in the South Bronx. I spent a number of years there, primarily as a litigator and a supervisor of litigation. From there, I decided to work for labor unions. My next stop was at DC 37 Municipal Employees Legal Services, where I spent a number of years and created their family law department. They weren't doing family court litigation until I got there, and we created that. Now they're very active in the field. From there, I went to Building Service 32BJ Legal Services Fund, another labor union that has a prepaid program for their membership. And from there, I actually was, in the middle of all that, I briefly worked for a plaintiff's negligence and medical malpractice firm. I did that because I like trying cases, but then I decided I needed to get back into legal services, so I did. But from there, I was appointed to the bench by David Dinkins in the early 90s, and I did spend 10 years on the bench. I left to go into private practice and start my own firm, but I stayed on the bench for an additional 8 years, so I spent 18 years in the place. But the second stint was, as I say, part-time. Most of my background, a lot of my background, starting out really by happenstance, was in family court. So,
thank you.
Short summary.
And just to explain, we decided today the best way to proceed with this conversation was really to have a conversation. So I'm going to start. Diane will be picking up, asking the judge some questions, and we invite questions from all of you, as well as for those of you watching on your computers at home. The questions are divided into categories, and so we would encourage people to hold their questions till the end of a category, and we'll integrate the questions we get from the viewers at home as well, or offices, I should say. So I think your background's really interesting, and I don't know if you can answer this, Judge. One of the things that you've talked about, we discussed before today, is that every judge comes to the bench with a different background. Do you think that your background, from your experience, was your background typical of the backgrounds of other family court judges, or different, or?
Well, I don't think judges come from many different backgrounds. Some of them have experience in family court, some of them don't. I don't think that's necessarily bad. I think, experience in other areas of law brought into family court is often a good thing. And I don't think that necessarily judges come to the family court bench with a judicial philosophy as such, but they certainly come to the bench with a perspective based on based on their prior involvement in family court as a practicing attorney. As I say, I was a legal services attorney, and prior to my appointment, most of my background in family court was child protection and related foster care litigation, custody, access, visitation, domestic violence. I also did do some juvenile delinquency. So my perspective, I can only tell you about my perspective, and I think it's different with different judges, but my perspective was that that I didn't think the law was always applied in the way it was written. For example, the Family Court Act is a very progressive procedural statute in my view. I mean, for the most part, the more elaborate articles have more detail, but I think it's a fine statute. But my experience was that it was often not applied the way it should be applied. And I also felt that this term, the best interest of the child, which everybody's heard, yes? Everybody knows what that means? Because if you do, you and I have to meet afterwards and you explain it to me. But I thought that this term, best interest of the child, was misapplied often and used as a cover sometimes for judges to simply rule based on their personal beliefs, personal opinion as to what should happen in the case. The best interest of the child is a standard that I know is not easily defined. I mean, I can tell you today that I have no better idea as to what that term means than I did when I started decades ago. Some commentators have written that this standard best interest of the child is vague, ill-defined, and accords judges so much discretion that it's often impossible to predict how they're going to rule in a particular case. Or with similar facts, judges will rule differently. In other words, my perspective when I came to family court was that I had to apply the law, and didn't believe it was ever appropriate for a judge to rely on any degree of personal opinion. To do otherwise, I think, is a disservice to everyone and to the law, and invites anarchy in the adjudication process. But let me be clear. I don't advocate doing away with the best interest of the child standard when that application, when that rule has historically been applied. For example, in custody cases between people with the same status, parent versus parent, non-parent versus non-parent. I mean, that's the legal standard. And that standard does allow for appropriate discretion and allows the judge to tailor a disposition to the facts and to the circumstances of the family. And of course, no one wants the outcome of a case to be contrary to the best interest of the child. But I've learned through many years of practice, on both sides of the bench, that reasonable people can legitimately disagree over what is in the best interest of the child. For example, I've had cases where I've had 6 or 7 parties before me. It sounds like a RICO prosecution of some kind, but a complicated child protective proceeding where there's an attorney for ACS, there's an attorney for a child care agency, there may be a foster parent, there's a couple of parents, they have lawyers, there's a couple of attorneys for the children because they may have a difference of opinion. So you have 6 or 7 lawyers, and they're all in front of me beating their fists on the table, telling me that I had to do what was in the best interest of the child. The problem was that they all had a completely different idea as to what that meant. So your job as attorneys, I'm going to digress a little bit, is to educate the judge because as to what really is in the best interest of the child in a particular case, or the judge is going to default to preconceived attitudes and just kind of pigeonhole you. The evil to be avoided in misapplying the best interest of the child standard, in my view, was best articulated by the U.S. Court of Appeals for the Second Circuit in a case entitled Duchesne versus Sugarman. If you're interested, you could look it up. It's at 566 Federal 2nd at page 817. 566 Federal 2nd, 817. It was decided by the Second Circuit in 1977. Duchesne was a 1983 damage action that was commenced by parents of several children against what was then called the Bureau of Child Welfare. Has anybody ever heard that phrase? Okay, you have to be around a little while to know. But on the street, people sometimes still call it that. You know, the name has been changed over the years for various reasons. We'll let it go at that. But anyway, so the parents sued ACS I'm sorry, sued ACS, or what was then BCW, because BCW had seized their kids and held them in foster care for years, underline the word years, without any court order and without the parents' written consent. There was no voluntary, there was no court order, there was no nothing. These kids were just in foster care. So they brought this action, and the parents claimed that by seizing the kids, their constitutional rights had been violated. In reversing the district court's dismissal of the complaint for the failure to state a cause of action, the Second Circuit wrote the following: "Of course, the deprivation of liberty involved here was purportedly based on the best interests of the children, and hence is not precisely akin to that caused by an arrest. Nevertheless, of all tyrannies, a tyranny sincerely exercised for the good of its victims may be the most oppressive. Those who torment us for our own good will continue to torment us without end, for they do so with the approval of their own conscience." That's the speech. Okay. Next question.
So, following that, I'm going to return us a little bit to the day-to-day mechanics of the court, but keep all of that in your mind, of course, because that will seep through the day-to-day mechanics. So if we could start at the beginning of the day, can you talk about what you would do to prepare for the day on the bench?
Okay, I can only tell you what I did, and because we were just discussing this a little bit before this program began. The experience of a family court judge is that you're running a little law firm, as it were, and every other judge is doing the same thing, and you really don't have a lot of communication with other judges and what they do, although you may hear anecdotally what's going on around the courthouse. So that said, I can only tell you what I did, and the experience of a family court judge actually is somewhat overwhelming on a daily basis, because you've got a calendar of 30 or 40 cases, and you have to deal with them all in some fashion. And I used to say that I could deal with any case family court had to offer, the worst kind of case, but I couldn't deal with 10 of them between 1:30 and 4:30 in the afternoon. So the experience is overwhelmed. What do you do to try to get on top of the caseload? What I did personally was the night when I finished for the day, I would look at the cases in the calendar for the next day. I would go through the jackets. Didn't spend that much time, maybe 45 minutes, maybe 50 minutes. But I personally review the cases. If there were reports that had been submitted to me, I would review them. It wouldn't take long because I'd already read them. I'd also review my notes on what was then called F-99s, the endorsement sheets. If I had written or made some kind of preliminary or earlier decision in the case, I would refresh my recollection about that. If there was a motion that was going to be heard tomorrow, I would review the motion papers again because I had already looked at that when it came in. And in that way, try to educate myself and get on top of the details of the case the night before.
And then the day of, how do you prioritize hearing the cases, and what's the role of the other professionals in the courtroom, the clerk, the court officer, et cetera?
Well, okay, so obviously if there was a hearing set for a time certain, I'd expect the people to show up. But mostly everybody here has appeared in family court. Yes, is there anybody here who's not appeared in family court? Well, you know, I'm truly not trying to be cynical, but it's a case study, and often, at least in New York City, in chaos. I mean, there's numbers of parties, there's numbers of lawyers, and if I don't have a case that's a time certain where presumably everybody's going to show up, you can only call a case if everybody's there. The only time it seemed to me that everybody actually showed up all of a sudden was if I left the bench and went upstairs for 10 minutes, and I'd come downstairs and find out there were 5 cases ready to go, and where was I? You know. But so the court officers are there to do a couple different things. Obviously, they call the calendar, they swear people in, but they try to assemble lawyers, because so many lawyers are institutional lawyers in family court that they're all over the place. The court officer has some idea where they are, has some idea when he can pull cases together, and so the court officer will do that, and of course provide security in addition to all of that. So who else is in the courtroom? There's a parts division clerk, the clerk in the courtroom, who's assigned to you, who sits next to the judge. I mean, they're responsible for the calendar in the sense that cases may have to be added, files may not be in the courtroom that need to be in the courtroom. They'll get that. They'll manage the mechanics of moving the cases through the courtroom. The other people who are supposed to be there, I mean, I just expect the lawyers to get there at some point and be familiar with what they're supposed to be doing and be, you know, prepared. I don't know, did I cover everybody?
I think
Who's left? Court attorneys?
with the court attorneys and the attorneys for the parties, obviously.
Yeah, well, the attorneys, well, you know, little control over them, more control over the court attorney, right? At least you know where the court attorney is. I'm looking at Gabriella, right? But how judges use court attorneys varies and is very different depending on the judge, number one, and depending upon what kind of part you're sitting in. If you're sitting in a part that deals with what we call V's and O's, custody, visitation access, and family offense, the court attorney will spend a lot of time talking to the parties and attorneys, if there are attorneys, to try to size up the case to see if it can be settled on some basis. If you're in a part where you're doing other things, for example, presiding over juvenile delinquency cases, the court attorney would do much more research and writing than they would in a custody and family violence part.
And before you take the bench, how much training did you receive on domestic violence?
Well, I worked in programs that dealt with domestic violence, so I did have training and you know, knowledge of domestic violence and how I thought it, and ideas as to how I thought it ought to be dealt with. But judges come from different backgrounds. I mean, there is training for judges on the bench, and there is some training involving domestic violence for judges.
And how about your perspective from the bench regarding pro bono attorneys, volunteer attorneys, since a lot of people, I think, listening today and watching the video will be volunteering. Did you have a perspective on volunteer pro bono attorneys versus the institutional providers you mentioned before?
Well, I thought they were great. I thought they were great because they had the resources to work up a case ahead of time. They clearly knew what the law was. They knew what the facts were. You know, the case was well prepared. You know, the downside was that most pro bono attorneys hadn't spent much time in family court and didn't know, you know, on a day-to-day practical level how the place operated. So the institutional lawyers knew that and could play that. But I think I always wanted pro bono attorneys. I thought it was great. I think most of my colleagues felt the same way, frankly. I think the institutional lawyers and the people who were in family court all day long sometimes felt envious that they didn't have the resources available to pro bono attorneys and didn't have the time to spend working up a particular case in the same way a pro bono attorney did. But I thought it was clearly positive for me personally, the cases I was presiding over and the system in general.
Do you have any suggestions for volunteer attorneys, getting back to what you said earlier, that you've got an incredibly heavy caseload, that the court officers are trying to juggle these institution attorneys who are all over the building and trying to get everybody in the same place at the same time for you to hear the case? That often results in delays in hearing cases. Do you have any suggestions for volunteer attorneys about how they might try to manage that, if that's manageable, who they should appeal to should they be waiting for hours for their appearance in front of the judge?
Well, you know, that's the family court experience, that you go down, whether you're an attorney or a litigant, you go down there and you spend hours in the place, and all of a sudden the court officer comes running out of the courtroom, yells your name, you jump up, you run into the courtroom, and like 2 minutes later, the whole experience is over. You know, and I've had, as a lawyer, I've had litigants say to me, "What happened in there?" And I said, "I have no idea." They said, "No, you're the lawyer. You must really know." I said, "Well, it's kind of hard to sort out exactly what's going on, except that the system is enormously slow. Sometimes it's too fast, but mostly once cases get going, it's too slow." Look, I think the only thing you can do, you can't change the system. Yeah, I learned that after about 30 days on the bench. I was going to change the whole place, and then I learned I wasn't changing very much at all, except you know, I had the ability to rule on the case I was presiding over. But what pro bono attorneys might do is find out where the other lawyers are, stay in communication with them, and try to assemble, you know, the lawyers that needed to be there if they could. If there's anything they could do to get lawyers there or to help the court officer out in that regard, you can get your case called quicker. But it's kind of hard to avoid spending a lot of time in family court.
And how about some of the other things that can happen in that forum that can be a bit confusing? What about when a judge insists or really wants to speak directly to a litigant as opposed to the attorney? When do you think that's appropriate? And is there a way for the attorney to redirect the judge to themselves?
You mean in the courtroom itself?
Yes.
On the record. Well, there are judges who believe that speaking directly to the litigant would have a significant impact. And I'm sure that judges direct comments right to a litigant because they think maybe they can get them to change whatever they're doing that the judge wants them to do differently, and maybe facilitate a settlement of some kind. But look, if a judge wants to speak to a litigant, I know you may not want the judge to do that for a variety of reasons, but there's not much you can do. I mean, you could say, Judge, I'm the attorney. Please direct your comments to me. Whether that's a good idea or not, I leave to you. But I would say it's hard. You're not going to reform the judge and get the judge to do things very much differently simply because you squawk a little bit. So you have to pick your battles. Now, whether you want to pick that battle or not, I leave that to you in the circumstances.
And similarly, what about settlement negotiations before the judge? Is it a good idea to have that conversation before the judge? And I think the concern behind this question is, what if settlement doesn't occur and then you're proceeding with the case and those options have been put in front of the judge who's then deciding the case?
Well, I understand the problem. I mean, you don't want the judge to find out all the bad facts in the case. The judge will or hear about evidence that may never be offered because there's some problem with its admissibility. I mean, I understand the problem. But if you look at the court rules, there are court rules that apply to family court. In any event, there's a specific rule, and it's 22 New York Code of Rules and Regulations. I think it's 205.7 or thereabouts. It says that the judge can hold conferences, and at the conference, the judge can do a number of things, including figuring out what discovery is necessary to the extent there is discovery in family court. But one of the main things that's listed that a judge can address at a conference is settlement. So, I mean, the court system itself recognizes that judges can hear about the case, in a conference and hear about what the evidence might be, even though you don't like that very much. The best you can do, I think, is simply try to advocate your position in that context as best you can and tell your client's story as best you can. Litigators are nothing but storytellers. And you have to tell a compelling story, and you can do that in that environment as well, in a settlement conference or some kind of conference with the judge.
And similarly, what about off-the-record conversations? When do you think it's appropriate or likely to have an off-the-record conversation? And is there anything an attorney can do if they want to get that conversation back on the record?
Yeah, I think that it's fairly common, whether it's right or wrong, it's a fairly common practice for judges to go off the record. Either they take the lawyers into the back and go off the record, or you go up sidebar and they turn off the machine, or tell the court reporter to don't take anything down. Is it right? No. The question is, how can a court of record conduct proceedings that are off the record? It's oxymoronic, right? It doesn't make any sense. So I think that if you want to make that an issue, you can. And I think that most judges would respond. They may not be happy about it because they want to talk off the record. Why do they talk off the record? Because they think that they're going to get the real information at that point. They're going to find out what's really going on without a record being made, and they think that'll help facilitate, or at least facilitate, a disposition of some kind. But I think you can say to the judge, look, Judge, I object. I'd like to have this all done on the record if you don't mind. Can we please do that? And I can't imagine, the judge may not be happy about it and may grimace or give you not nice look. But my feeling is, whenever I've done that, that judges will go on the record because they know they have to.
And what about, we talked about delays, just the delay of this, spending a day in family court, the cases are called at different times. What about delays because parties may not be responding deadlines? Is there any way that attorneys can get the court to address that? And can you explain why there's at least a perception among a lot of volunteer attorneys, I think, that missing deadlines is not taken particularly seriously in the family court?
So, but just give me an example. What kind of deadline?
Do you want to answer that, Diane? Any production of evidence or
exactly. I mean, it happens, more often than not in our child support cases, which, as a practitioner, I think that you could speak to. Oftentimes, the respondent is advised to produce his financial disclosure affidavit, produce, statements regarding his income, and from court appearance to court appearance, months pass, and there's no production. So at that point, when does the court say, okay, we're moving this forward, or allows you to make a motion to compel, because we've talked about discovery issues. So I think that's where that comes from.
Well, you can make a motion. You can make a motion to compel, certainly, but the remedies that employed may be problematic, because I can tell you that the appellate division doesn't like family court judges deciding cases on technicalities. They want, if they haven't said it directly, that's what I've learned over the years, at least by implication. They want you to rule on cases on the merits. So you can't say, okay, you're precluded at this point. I mean, you can try that, but ultimately that's going to be given a lot of scrutiny on appeal if it goes up. But you know, the experience, as you know, the experience in family. Am I on? Mm-hmm. Okay. The experience in family court. Okay. The experience in The experience in family court is, as I said, it's overwhelmed. I mean, everybody's overwhelmed. The judge is overwhelmed. The lawyers are overwhelmed. The parties are probably overwhelmed too. But everybody's overwhelmed because of the numbers of cases and the limited resources in the court, and all the things that can go bad in family court and are problematic and not good for litigants. I mean, yes, it's true. You have to. I'm not suggesting that deadlines shouldn't be upheld, but it's way down on the list of things that need to be addressed in a particular case. So, and plus, you've got so many cases competing for a support magistrate's time that they tend to say, okay, I'll give you more time to do it. Is it right? No, but it's what happens in family court. But keep on pushing the point, and I think eventually, you'll get what you want without an artificial sanction. Then no one's going to preclude evidence or any of those remedies under CPLR 3126, I think it is. But eventually, you'll wind up getting the information that you want.
Just as a follow-up, if I may, Amy, we talk about also, a lot of issues that do come up is there's been a trial, a hearing's been held, all the witnesses, and no decision has been rendered. And it takes some judges in many of our boroughs many, many months to write a decision. And we were wondering if maybe you can talk a little bit about why that happens.
Well, it happens for the same reasons that I mentioned. I mean, it's too many cases, not enough resources. And one of the pieces of advice that I got when I started on the bench, actually from Judge Judy, was that don't reserve decision in a lot of cases because you'll forget everything that happened, and then the case will sit there, and then you have to get the transcripts. And I never wanted to read transcripts because I had to sit through the thing once. I don't want to read about it twice. I just want to remember what people said. But there are judges who just get fired up and want to write a decision, and then it sits there for a while, and then it never gets done. I was always so deathly afraid of having so many cases, submitted with decisions that I don't think that I could count on one hand the amount of times I didn't release written decisions within a week of the submission, just because I was so afraid that I would get so many of them and I couldn't remember. But it's a function of lack of resources being overloaded and, judge having too much to do. Maybe it's better to do more on the record sometimes, but that happens. Now, so then what do? You don't get a decision. It goes on and on and on. All lawyers are afraid to bring it to the attention of the judge. Say, oh my God, if I do that, the judge is going to be angry. They're definitely going to rule against me. I can tell you that that's not the case, in my opinion. I don't think that's true at all. I think that you can call up the court attorney, ask the court attorney to kindly raise it with the judge. You've been waiting. It's problematic. There's no decision. This happens in Supreme Court as well. I mean, I had a case not long ago where there was a year after a divorce trial, no decision. So we started to make some noise. And yeah, sure enough, we finally got the decision a couple weeks later. And we won. So you don't have to worry about losing by complaining.
Great. Thank you. Are there any questions? I'm going to pause for a moment and see if there are any questions from the room about anything we've discussed so far. No. Yes, in the back.
I haven't heard the place in the court calendar to see if any of the cases have settled or need to be sent out for mediation or settlement of any sort.
I'm sorry, what was the question there? You haven't heard about the place in the court calendar?
I haven't heard in the place of the daily court calendar where the judge says, now have any of you settled, or go out in the hall, or I'll take the uncontested cases first.
So I guess your question is, does that happen, or what? Okay, so.
The encouragement for mediation or settlement.
So how in the system, I'm just repeating the question if I get it right, I hope, where is there a place in the system to encourage settlement or mediation?
Well, it may not be on the calendar, but I can tell you that the number one, not the number one of the high priorities that every judge has is to settle a case, if it can be settled, to explore what's going on, to see if there's any compromise possible, no matter what kind of case it is. You can walk into U.S. District Court. The first words out of the judge's mouth are going to be, can the case be settled? I mean, it's just like automatic. I think, so it may, they're not segregated on the calendar as such, but I think that once the case is reached, in some fashion, every judge will size up whether the case can be settled, or if it couldn't be settled before, can it be settled now?
Anything else? Yes.
You mentioned is that each judge does their own thing, and that's one of the things that I found really challenging practicing in family court, is that every single judge seems to have a completely different understanding of how things are done, and are so incensed when you don't already read their mind and know that they want things filed in this order or whatever. Like, I guess the question would be, like, why isn't there more uniformity or oversight to make it so that you can walk into a new judge's courtroom and know what to expect? And how, like, what is the cross communication like around cases and interpretations of the law and procedure?
So just to restate the question, as has been mentioned, it does seem as though, depending on which judge you go in front of, there are lots of different expectations. Decisions can be made very differently, and not just the subjectivity of the decision, but actually the procedures and the way in which the judge expects the proceeding to happen in front of them. What is done within the court to create some level of uniformity? Is anything done to create some level of uniformity among the family court judges?
Well, I don't think on that level, but I tell you that when I started practicing in family court a long time ago, I had the same experience. You know, you'd walk into a courtroom and every judge had a different procedure. If you didn't immediately understand what they were doing, they would say, well, it would seem that you were at fault because somehow you don't know what's going on, as opposed to there's 10 judges in this courthouse that deal with things about 15 different ways. So there's nothing you can do about that. That's the way it is. And judges, I mean, most of what, look, domestic relations involves a load of discretion in general. What happens in family court is even, is also highly discretionary. And judges tend to view things from different perspectives. I think, and honestly so. I mean, they may honestly want to apply the law as well, but they come to a different conclusion based on the facts, or they consider a particular factor in a custody case more significant than other judges might. It's just what happens. That's why forum shopping is a time-honored tradition in American jurisprudence. Yes.
Going back to the question of delay, sometimes it seems, especially if you're representing a survivor of domestic violence, that the abuser uses delay or additional motions as another way to try to exercise control or power over the survivor. And sometimes it seems like the delay itself is not in the best interests of the child. So how do you, because it creates uncertainty and disruption to keep coming back to family court over and over again, so how do you bring those issues to the fore in a way that a judge will be receptive to them, given what you've said about the concerns about deciding things on the merits?
Well, delay.
I'm sorry, Judge, let me just repeat the question
yes.
so everyone can hear it. So the question was regarding delays, in particular with domestic violence cases, when sometimes the delay in the proceedings in a custodial matter, for example, can be negatively impacting the child. Just the delay itself can be harming the child and therefore not in the best interest of the child. And the perpetrator may be using those delays as a form of power and control over his or her partner. How do you bring those issues in front of the judge?
Well, there's no question that delay is bad for everybody. Delay is, in domestic violence cases, delay isn't good for the petitioner. It's good for nobody. In custody cases, certainly delay is not good for kids. It shouldn't have to take a year or more to sort out a custody case. I mean, it's just bad for everybody. Here again, the problem is lack of resources in the family court. You're not going to be able to eliminate it. What you can do is try to convince the judge how serious this case is, as opposed to all the other cases that judge may be presiding over, and argue that it's really damaging to the child. We need to do this faster, etc. And if you say it respectfully, I don't see any downside to that. It's just that you may not be very successful given the system we're dealing with here.
Can I follow up and just push on that a little bit? If there are delays that seem like unnecessary delays, and we've talked before about how sometimes the judges will permit delays, if you will, because they too have an overloaded case calendar and may be happy to push things off, it starts to feel sometimes to a domestic violence litigant that the judge and the other party are supporting delay when the domestic violence victim is trying to prevent delay. So is there some way to bring that complicated connection to the attention of the court? Well,
what I did is, yes, I would say, look, again, every judge does it differently. What I would do is I would say, look, the trial's going to start. There's no settlement. We're just going to set a date. We're going to do it. But typically, as you know, what happens in state courts, both the Supreme Court and the family court, where there are bench trials, the judge takes a little testimony, kicks it over for who knows how long, a month, 2 months, and then keeps going, and it can take forever to try the case. I didn't do that, actually. Well, I thought it was bad, but also for selfish reasons, because I wouldn't remember what anybody said 3 months ago. So if I started a trial, I would continue that trial as much to day as I possibly could, even if there was only a little time in the afternoon to get the case. The people would all squawk, the lawyers would carry on, but I'd say, no, you're coming back, the trial started, and we're going to do it, and we're going to get it done. And as a result, the vast majority of the cases I presided over were done, quicker than they might have been otherwise if I had just gone along with the program and adjourned it for months. But, some judges are better with a calendar than other judges. It doesn't matter what court you're in. Or where you are, sometimes it's just very, very slow.
Yes.
So I have two-part question. But the delay and the settlement, because of the delay, it does tend to push towards settlement, I think. But there are times when we want there to be a fact-finding. For example, as I practice immigration as well, and sometimes we want a fact-finding so that we can ultimately maybe get a certification for the crime that was committed, the order of protection, or the domestic violence crime that was committed. So if it gets pushed towards settlement, and because of the delay, I mean, how much can we as practitioners push back and say, no, we actually want a fact-finding, if one side is saying, we'll settle, and we don't want to settle?
Well, I understand the reason why you want the fact-finding, and I mean, it's at least theoretically possible to have a consent fact-finding, although that's never going to happen because the respondent won't agree to it, or usually wouldn't agree to it. Most of the time I insisted upon that in child protection proceedings where people made admissions. I wanted specific admissions to specific facts. But look, I think if you explain to the judge why you need a fact-finding and that you can't settle the case on some general basis, we'll just give you an order of protection for, for however long, I think the judge will understand. And besides which, even if the judge doesn't understand, the petitioner filed the lawsuit, has a right to an adjudication. So as much as the judge and everybody else carry on about how your position doesn't make any sense, you can say, no, it does make sense, and it may take more time, but I'm going to be here, and we're going to try this case, and eventually it will be.
Great. So I think, Diane, you were going to move on to some courtroom etiquette and procedure questions.
I know that we have many of you are seasoned family law practitioners in the audience, but part of our program was going to be geared toward talking about the practical courtroom etiquette for new practitioners, and we've all been there at some point in our lives, or we're just starting out, walking into the courtroom for the first time. So what I wanted to talk to you about in this section, Judge, is I walk into a courtroom, depending upon the size, where do I sit when there's no indication to sit?
Well, sometimes there are no chairs.
Right. So what do we do as new practitioners? If do you have any guidance as to when we walk into a courtroom? How do we familiarize ourselves with the settings, and really what is the setting in the courtroom?
Well, okay. In family court, if you're the petitioner, as you face the judge, you're going to sit on the far right. The respondent, as you face the judge, is on the left. And if there's an attorney for the child, sometimes they kind of sit wherever, but they might be even further to the left, more typically at the end of the table. So, and that's how it sets up. If you're not sure, you can always ask the court officer. Any of these questions before you see the court officer coming and going, you go up to them and say, "Look, I'm new to the family court. Can you just explain to me the following? Where do I stand? What do I do? How do I get a copy of the court-ordered investigation, for example? Can you give it to me now? Do I have to wait to go inside?" Just ask the court officers, and they're happy to help you. The only time where that setup in the courtroom may be different is if you wind up in an IDV part, which is a Supreme Court part, and you're in a courtroom with a jury box. The plaintiff, petitioner, the people in a criminal case all sit closest to the jury box, and the respondent, defendant sit on the other side. That's the only exception. So, for example, in Brooklyn, I think that may be the case. But you'll find courtrooms where that's the case. The jury box may be on one side or the other.
Okay, great. And I know that when I was first starting out in private practice, it was always taught to me that I'm always addressing, whenever I address the court, I'm to stand, speak directly to the judge. Is there a particular way, is there a particular preference that you had when practitioners entered your courtroom and spoke to you and addressed the court?
Well, okay. You should, anytime you address the judge, you should stand up. I mean, I didn't need the, it wasn't for me personally, it's the institution. But the presumption should be you stand up unless the judge tells you otherwise. Now, sometimes the judge will say, no, this is just a conference. You don't have to jump up. Just feel free to stay seated. Then you can stay seated. Otherwise, you stand up. What you call a judge is not what you call a judge outside the courtroom. You have to say, Your Honor, or Judge. Judge is fine.
Okay, great. Thank you. So, if I'm the petitioner in the case, do I start speaking to you directly as soon as you take the bench? Do I wait until you begin talking and addressing the courtroom? How does that all play out?
Okay, well, if I had my judge's hat on, I would say, no, I don't want you to say a word unless I ask you to say something. But I've spent a career also being a lawyer in which I've jumped up like a jack-in-the-box and tried to grab the floor before anybody else because I want to be seen as the most knowledgeable person in the courtroom, the person the judge is going to look to know what's going on in the case. I'm telling, in that sense, I'm telling my client's story because, after all, we're storytellers. That's all we do as litigators, whether you're arguing before a jury, writing a brief for the Second Department, at a conference, trying a case, whatever it is, you're a storyteller. So that's what you do.
Great. So I know that oftentimes we all run into difficult adversaries where a lot of...
I'm sorry, meaning what you do is you try to jump up and grab the floor. That's what I meant. I'm sorry. I don't mean to interrupt you.
No, that's
What's
fine.
the worst that can happen? The judge says, did I ask you to say anything? Please sit down. Okay, so you sit down. You're not going to jail.
Right.
Okay.
And you're not a real lawyer until you get yelled at by a judge.
Right.
So that's your initiation.
In fact, only half kiddingly, I mean, as a legal services lawyer, I used to say if the judge wasn't angry at me at least every half an hour, I wasn't doing my job.
That's right.
So
on that note, it's getting a little slack from the judge is okay, but what about if you are dealing with a difficult adversary and that adversary is really not allowing any kind of communication outside the courtroom and you're only moving the case forward from court appearance to court appearance, which drags out the case also. How do you deal with adversaries who are either not responsive or not willing to communicate in ultimately settling the case? Because most of the time, more often than not, we as practitioners want cases to settle, depending upon the circumstances, of course. But how do you deal with someone who is not responsive to outside courtroom discussion?
Yeah, well, that happens because you have institutional lawyers who, only deal with the case when it actually gets called. But there's a way around that because we all know the judge wants cases to settle. So at some point, depending on the circumstances, when the court attorney comes out, you can say, look, we're really trying to settle this case. It can be settled, or we hope it can be settled. It's certainly reasonable to conclude that it might be settled. But I'm having trouble talking to the other lawyer. Can you help me out? The court attorney will either go take care of it or involve the judge and tell the judge. You can tell the judge directly in a conference, look, Judge, we've been trying to make settlement proposals here, and the other lawyer, I can't get a hold of him. I'm not criticizing him, but is there something we can do about this? The judge will go for the bait, believe me, and indicate to the lawyer to start talking. So
Great.
I think that's how you deal with it.
Is there any way, is it at any point appropriate for, under that circumstance, for example, is it any way appropriate to contact the court by either a telephone call or by letter, advising your adversary of the time of the call that you're going to be placed into the court, or advising the adversary by CCing in a letter? Is there any point where that type of correspondence is okay to the court?
Well, you should never write to the judge. You might get away with writing to the court attorney, who will immediately tell the judge, so it's really the same thing. But no, you're not supposed to engage in ex parte communications at all. I think letters are frowned directly to the judge, certainly are frowned upon, unless the judge indicates otherwise. You know, if the judge says, let me know by letter, copy the other side if something happens, and go ahead and do it. But otherwise, no, I wouldn't. And as far as telephone calls are concerned, you're never going to get the judge in a family court part. It's much easier to get, well, you're not get the judge either in a Supreme Court divorce case or family court. They're too busy. They're on the bench. And most judges, court attorneys, are not taking a call ex parte. If both of you are on the phone, okay, you may have a shot. But don't call up yourself. They'll just yell at you and won't talk to you.
Okay, great. And at some point, we didn't begin, we should probably have talked about this a little bit earlier, but maybe you can explain the difference between the support magistrate, the court attorney referee, and of course the judge. I mean, we know a little bit about what the judge's role is, but what is the difference between those three individuals in the courthouse?
Well, okay. I mean, obviously, the judge is a judge under state law. A support magistrate is not, but by statute, they exist and preside over support cases subject to objections from a final order to a family court judge. But they really have complete power to try the case, issue subpoenas, do whatever. The only thing they can't do is lock anybody up. They can make findings with respect to contempt, but it has to go to a judge to confirm and to actually lock somebody up. And I don't believe they can issue warrants either. I think a judge has to do that, although I may be wrong about that at this point. But did that change your knowledge?
I
don't think.
I only thought a judge could, but.
Yeah, I think it's only a judge. I mean, all of this is a function of too many cases, not enough judges. So the court system kind of comes up with other types of judicial personnel to try cases, to move cases through the courthouse. So that's what a support magistrate is, limited to support litigation, and it's varieties of same. Referees are court attorney referees who are straight up referees under CPLR Article 41, I think it is. There's two kinds of referees. One is to hear and report, which means they can try the case and make a decision and subject to confirmation or rejection by the judge. And one is to hear and decide, which means they're the judge at that point. And but whether you have one or the other depends upon you, because you have to agree to have a referee involved in your case. And they may pretend otherwise in family court, but that's really the law. And you can agree that they'll hear and report or hear and decide.
Just as a follow-up to that, because I know that many of us have come across judges who may be busy and can't hear a trial when it is time to try a case, and they'll refer the case to a court attorney referee or a special part who will hear those trials more expeditiously than the judge. What's the downside of that happening? Because as a practitioner, I know I worry about, this judge that I was before for a year knows the facts, knows the parties, knows the issues. What's going to happen now that it's going to a completely different person to hear the
Well, actually, it may be good, because you may not like the judge's attitude toward your client. I mean, getting back to my offhand comment about forum shopping, this is just another variety of forum shopping. So I always, whenever I get a new case, whenever I've gotten a new case as an attorney, I do as much as I can to find out about the attorneys on the other side and who the judges are. I look them up on Westlaw. I put them through some of these sites where virtually whoever won the case thinks the judge is great, and whoever lost says the judge is a complete moron. You know, but it's worth looking. There's some information there. Ask colleagues whether they've dealt with this judge, and and to the extent that you can maneuver a case to somebody else because you can't stand the judge, or vice versa, you do it. I don't know. So does that answer the question?
So it wouldn't necessarily be a bad thing. I mean,
I don't think so. I think the referees are good. I mean, some of the referees, in my opinion, are better than some of the judges. I mean, it's just that they're not judges.
Do they have the same training, or offer the same training as judges?
No. They don't go to the judicial programs, but certainly, they come to family court with background and knowledge, and some referees. Recently, one of the referees in New York County became a judge.
Great. Just one other last question about courtroom etiquette and procedure. I know that a lot of us who are handling custody and visitation cases come across court-ordered investigations. Those reports are accessible, but how are they disseminated by the court, by the judge?
It's strictly up to the judge. The attorney over here said, "Why do judges have different procedures?" Well, this is one of those different procedures. So if you go into the IDV part in Brooklyn, if there's a report from ACS, they'll give it to you right at the outset when you sign in because they have that procedure. Sometimes in family court, the court officers will just hand it out. I mean, the judge will say, make sure everybody gets a copy of this. Here you go. And the court officer will give it to you. Some judges want to pass it out after the case is called and give it to you then. It's just judge specific. But no problem asking the court officer or the parts division clerk, how do I get a copy of the COI? And they'll tell you in that part.
Great. And similarly, in terms of handing up information, let's say you have an affidavit of service and you need to hand it up, quote unquote, to whom do you hand it?
That's a good question. Okay. To make sure that the judge actually gets it, you have to assume that some judges are more interested in that than others. But if you want to make sure the judge gets it, I would hand it up in the courtroom when the case is called. Otherwise, you could file it ahead of time. Make sure, I would say anything you file in family court, make sure you have a copy that the clerk can stamp as proof that you actually filed the thing, because it's not unknown that stuff gets lost in family court, given the caseloads and how busy it is.
And I just wanted to follow up from her justice's perspective. A lot of these questions about the differences among the judges, those are the kinds of questions that our mentors will answer, and I'm sure mentors from other legal services organizations do the same. So it's a perfectly good question if you're a volunteer attorney to ask the person who's helping you on a case, not just questions about the law, but actually about what the judge you're in front of is going to be expecting, because it does vary by judge. Do we have any questions at this time? Because I think we'll be moving into talking a little bit about the attorney for the child. Yes.
Are there special considerations when one of the litigants is pro se, either for the court or for the attorney representing the other side?
Are there special considerations when one of the litigants is pro se, either for the attorney for the other side or for the judge?
Well, I would say, so many people do appear pro se in family court, so it's much more common for that to happen. But I would say in virtually any court, and I've seen pro se litigants everywhere from housing court, family court, up to the Second Circuit, no judge likes to deal with a pro se litigant because they don't know what they're dealing with. They may not know what they're dealing with the lawyer, but at least it's a lawyer. So, but there's a lot of I don't sound like Forrest Gump, but you don't know what you got, there. So they're certainly not going to take a litigant back into the back for these conferences. Everything's probably going to be done on the record. It tends to slow things down. Although, I did a lot of things with pro se litigants, people who often would waive counsel in family offense proceedings, and I'd take testimony and decide the case. So, but the case certainly will be dealt with differently by the judge, for sure.
Okay, great. So no other questions. Okay, great. So just moving on to the attorney for the child. We talked about different players in the courtroom. Attorney for the child is a very significant player, as we all know, in a custody and visitation case or in a family offense case, for that matter. And I know that as attorneys we have special, ethical rules that we have to abide by. Are there any special ethical rules that apply to the attorney for the child?
Okay, if you want to know about attorneys for the child, you should look at the court rules, and which you may be aware of already, of course. But look at 22 NYCRR Section 7.2, and this is a rule under the broader caption of law guardians, which is what they used to be called. But this rule says the function of the attorney for the child, and the rule, among other things, says that the attorney for the child is subject to the ethical requirements applicable to all lawyers, including but not limited to constraints on ex parte communication, disclosure of client confidences and attorney work product, conflicts of interest, and becoming a witness in the litigation. So the attorney for the child is just like any other attorney in that regard.
Okay, great. And I know that there are different views about the attorney for the child and the role that attorney plays in the case with respect to gathering information and really being almost someone that the court really relies upon for their opinion. How do you view the attorney for the child in a custody and visitation case?
Well, I go back far enough that there was some substantial ambiguity as to what the role was of the law guardian when I started practicing. I mean, some law guardians / attorneys for the child would act like a guardian ad litem, meaning they weren't there primarily to represent the child's, or advance the child's position. They were there more to assess what was the appropriate outcome, kind of like a mirror judge of some kind. And this all became far more clarified when Judge Judith Kaye, the Chief Judge of the Court of Appeals, got involved with this, and these rules started to be enacted to provide some clarity. Look, I think that nowadays you'll find, certainly in some divorce parts, the judges are reluctant for a variety of reasons to, or won't as readily appoint attorneys for the kids as might happen in family court for a couple of reasons. One is somebody has to pay for it if they have any resources at all. But secondly, attorneys for the child now, under this rule I just recited, another section says that you're supposed to advance and advocate the child's stated position, even if you think it's contrary to the child's best interest. Well, you can exercise independent judgment if you, as an attorney for the child, you come to the conclusion that the child lacks the capacity for knowing, voluntary and considered judgment, or that following the child's wishes is likely to result in a substantial risk of imminent serious harm to the child. And if you decide that you're not going to advocate what the child wants to do under this rule, you're permitted to advocate otherwise, but you still have to let the judge know what the kid's position is. Well, all right, all this being the case, it's not necessarily helpful to the judge as a fact finder simply to have an advocate there. I mean, it's more like they're on an even footing with the parents at that point if they're simply advocating positions. It doesn't necessarily help me reach a disposition that I think is best for this kid in these circumstances. Now, nobody knows, children come from the age of just pushed out of mom's womb to age 18. Once they become 18, legally, there's no more custody or visitation, even though you get to pay for them until they're 21 in a child support order. So nobody knows when. So if you're representing an infant, obviously the attorney is just going to advocate what they think is best for this child. If you're dealing with a 16-year-old, that 16-year-old has a right to counsel and to have his or her position advocated, even if it's half-baked. Where it tips, the tipping point, nobody knows. 9, 10, I don't know. Legal aid says 8, but nobody knows. It depends on the child, I think.
And how strong is the court's reliance on the recommendation made by the attorney for the child?
Well, if I know they're simply advocating a position that isn't necessarily what is in the best interest of the child, I'm not going to pay as much attention to it as you might think.
Okay. And is there a point where you would reject the court attorney's recommendation? I mean, the attorney for the child's recommendation at some point? And
Yeah.
what are under what circumstances?
Well, well, look, my kid used to come home and want candy for dinner. I mean, she's now an adult. I don't know if she eats for dinner anymore, but she wanted chocolate. I didn't give her chocolate for dinner because she wanted it. So my job is to sort out what I think is best, regardless of what the parents are yelling at me, telling me to do, or what the child essentially is yelling at me and telling me to do. I have to sort out. I'm supposed to be the mature adult in the room, and make the wise, intelligent decision as best that I can.
Okay, great.
So I'm perfectly prepared to reject everybody's position. Doesn't matter. I mean, it's equal opportunity. I'm going to do what I think is best.
So if, in custody and visitation cases specifically, under what factual circumstances would you agree to no visitation at all for either one of the parties? So you have one parent who's saying something, a child who's saying something else, another parent who's giving a different version of the story. Under what circumstances or state of facts would you say no visitation?
Well, it's so enormously complicated. I mean, children can be saying they don't want visitation for a variety of reasons that, it's got really nothing to do with their safety. But I mean, the law is that if the parent presents a severe, imminent risk of physical or emotional harm of some kind, even if the visitation is supervised, then in those circumstances you have the discretion to disallow visitation. Always, in my opinion at least, always with a plan as to how we're going to get past that and resume visitation, what needs to be done to get this going. It's certainly not to me, and I think to virtually every judge, not an acceptable disposition not to have any visitation at all. although sometimes in practice that happens. Now, where you draw the line is judge specific. You know, what might get some judges to say, I'm not going to order visitation right now, is not where another judge would come to the same conclusion, just up to the judge.
And under those types of, in those types of difficult cases, is the court more likely than not going to appoint a forensic evaluator in those types of cases, or is there more of a reluctance to do so?
Entirely judge specific. I tell you that as an attorney, I didn't like forensic assessments because I thought I was losing control of the case, and I wasn't sure I liked the forensic expert, you know, a variety of reasons. As a judge, I only appointed people that I knew were really competent, because a bad forensic expert can really screw up the case for a long period of time. So, you know, the parties would have input, but there would be a group of people who I thought were competent that they could choose from. But as a judge, I thought they were really helpful. Now, you order forensic assessments where there's either some significant psychopathology going on in the family, somebody's, you know, has some issues, or maybe more than one person. Or you can't say everybody is mentally ill for sure, but you want some idea as to what the dynamics are and what's going on. So I like them a lot. I don't think I ever tried a serious custody case without a forensic expert having conducted an assessment.
Okay, great. And
but many other judges feel otherwise. So it's very judge specific.
Okay. And can you describe a bit of under what circumstances discovery would be allowed in custody and visitation cases, which is often not downstate, more so upward New York State, but for those that are listening in?
Right. Well, in fact, there is some discovery. I mean, to the extent that the judge orders a forensic assessment, that's a form of discovery, I would say. But look, bottom line is, it's even upstate. It's a special proceeding. And the rules in the CPLR governing special proceedings, Article 4 of the CPLR, say that with the exception of a notice to admit, there's no discovery except by leave of court. So if there actually is a need, maybe a deposition of a non-party, parties might agree that in lieu of coming to court, the transcript would be admissible. I mean, that kind of thing. You make a motion. If you think that it's something legitimate, fine. But I can tell you that you're not going to depose the parties, at least downstate. I don't think that judge would readily do that. But if there's some other type of discovery you think is appropriate, document discovery from a non-party, that kind of thing, move forward.
Okay, great.
I would say that some judges view the discovery process as kind of a negative, that it slows the process down. It's just lawyers being lawyers. I have a different point of view. I think the discovery is valuable, and the more of it, the better, frankly. That doesn't mean I'm going to authorize depositions of everybody, but, you know, I've got, you know, an open mind. But here again, judges have different points of view, which are all legitimate.
And from a practical perspective, I think that, you know, going through that discovery phase would help settle a case as well, depending upon the facts that do come out. So I think it's a valid point to say that discovery is important in those types of cases. If the parties do come to a settlement, is there at any point, or under what circumstances would a court reject a stipulation of, you know, regarding custody and visitation between the parties?
Again, it's judge specific. Some judges, if they know they won't say this, but if they know the attorneys and trust the attorneys, will, you know, probably sign off on virtually, maybe not everything, but virtually any settlement that's proposed that looks reasonable on its face. But there are judges in New York City and upstate that you know, get much more involved and are not willing to add their name to a consent order, a consent judgment that they don't like. So they're going to say they don't like this, that, and the other thing, and it's got to go back and negotiate it.
Okay. And what about, what if domestic violence was a key factor in one of the custody and visitation cases that you were hearing, and the stipulation of settlement regarding custody and visitation allowed for joint custody, or even further, joint shared custody? I mean, would that be a factor that would play into possibly or potentially undoing a settlement?
Yeah, I would say absolutely. I mean, ultimately, you're asking a judge to sign on to a consent custody order and the child has to be safe and has to be good for the child. So if there's something that extreme that you feel hasn't been addressed, yes, I can definitely see a judge saying, look, I'm not signing off on this. You know, you could drop the case, go to another court, but whatever you do, I'm not signing off on it, you know. And then there could be more discussion as to what the judge might sign off on.
And if testimony is heard during a trial about domestic violence, would the court, why do courts, I mean, we've seen it as practitioners, courts are just still willing to order joint custody even after hearing that there is some domestic violence in cases. What is your position about that?
Well, look, one is a mechanical position. One is that under 240 of the domestic relations law, if the claim is raised, you're obligated to try it, make factual findings, and assess how it's impacting on the child's best interest. Now, the last part is where you get different perspectives. I mean, judges treat different factual scenarios differently. So, I mean, my own opinion is that to the extent that there is a finding that domestic violence occurred, that's a significant factor in assessing parental fitness. You know, that somebody would employ this as some method of resolving disputes or otherwise, or is just angry, you know, is a serious issue with vis-a-vis parental fitness.
Okay, I know that we are close to time, and I just wanted to open up the floor to see if there were any questions from the audience at this point regarding custody and visitation cases or the attorney for the child.
And online, if folks have questions, please do send them in.
So we were talking about the appointment of a lawyer for the child. Under what circumstances will the court consider appointing a lawyer for the child when in an order of protection case as opposed to a custody and visitation case?
So regarding appointment of lawyers for the children, when would the court consider appointing a lawyer for the child in a custody visitation case as opposed to an order of protection case?
Well, of course, it's discretionary. I mean, I think, and I've heard of it happening sometimes. You know, I think it's judge specific, but the judge might want to know if there's a companion custody case that's going to be filed or has been filed and there's already a custody disposition. I mean, I can see it happening. If you're interested in having that, you should ask the judge. But the judge will have a point of view right away as to whether he or she's going to do it. So.
You mentioned IDV part a bit earlier. Just one question about that. How are the cases heard in IDV for those that may not be familiar or consistent practitioners in the integrated domestic violence part? Are all cases heard simultaneously? Is the criminal court case heard first? Can you speak a little bit about that?
Well, of course, I never sat there, but I've certainly have appeared there as an attorney, and here again, it's judge-specific. But my experience is, at least in New York City, that the cases will all be held together because eventually the assumption is it'll be settled on some basis. So the criminal aspect of it will just be carried along, and the people will appear. And there may be misdemeanors or greater, or, you know, cases that are triable by jury, but they'll be held as they were filed until a settlement is made, or if you have to try it, typically an A misdemeanor be reduced to a B, so it can be a bench trial, and it'll go forward. Now, you can't try. You know, my experience is that you're not going to try them simultaneously. That's for sure, because of different burdens of proof, and you just can't do it. So at that point, they may be dealt with separately. But until the bitter end, they're either settled or tried. They're going to be held together.
In a family offense trial, what do you feel is the best type of evidence? Is it just your client's is the petitioner's testimony? Is it something more? Do you like hearing from witnesses?
Oh, yeah, the more witnesses, the better. I mean, look, it's certainly sufficient evidence if they each testify. I mean, if there's no other evidence except the petitioner testifies as to the allegations in the petition, that'll survive a motion to dismiss, even if you don't believe what they're really saying. I mean, it's prima facie sufficient. But eyewitnesses, absolutely. You try to bring that. We know it's difficult. People get a subpoena and they throw it in the garbage, and you know, I mean, you have to make some judgment as to what you're going to try to do. But if there are eyewitnesses or cops, you know, get the judge to so order some subpoenas for some of these people that really know something about what happened.
Okay, great. Before we get into a few questions about child support, and that's where we're going to be probably asking you to put on your practitioner hat to talk about some issues that deal with financial support. Are there any other questions, either online or in the audience, about custody visitation or the attorney for the child at this point? Yes, in the back.
I'm primarily an immigration practitioner, but I have a question about attorneys for the child. Often when we file guardianship cases in family court, and particularly upstate, even though we as the attorneys for the children file the case, we've encountered that the family court judge will appoint a second attorney as the attorney for the child And I'm just curious what your thoughts are on that practice and when that's appropriate.
So this is a question from an immigration attorney who's talking about appearing outside of New York City as the attorney for the child, and oftentimes the judge will then appoint another attorney for the child in that proceeding. Do you have an opinion about that practice?
I'm sorry, I don't understand. You were already the attorney for the child?
They said they have to have a panel attorney be the attorney for the child, and so if you're not a panel attorney, you can't represent the child on your own.
So the clarification was that upstate, if you're the only panel attorneys represent children apparently in upstate family courts, and so if you're not a panel attorney, even if you're bringing a case on behalf of a child, they will appoint a panel attorney for the child as well.
I mean, you can try to argue. So you're suggesting it may not be necessary. How do you avoid that?
Yeah, I mean, in my in my practice, it's been, even when that's happened, I'm doing all the work and the other attorney is just showing up. Yeah.
Well, yes. Well, certainly that's important for your client. You're just showing up and helping the other attorney. I mean, that's certainly valuable. But understand that if you step back from family court in any county in the state, I mean, the upstate counties may have more cases per judge than in some of the New York City counties, believe it or not. So everybody's overworked, overburdened. And since everybody's overworked, overwhelmed, overburdened, there are systems to guide the cases through the courthouse, and you're just getting mixed up in one of their systems. That's what they're going to do. There's not much you can do to prevent it, except try to talk them out of it and say it's unnecessary. Upstate, you can say, look, it's costing everybody a lot of money. Let's save some funds here. It's not necessary. The judge might respond to that. Judges are elected upstate.
Judge, we have a question from online. What is the best way to lay a foundation for evidence from another court? For example, a transcript from a criminal court sentencing hearing in which a party in family court makes statements contrary to the position being asserted in the family court.
Oh, that's a complicated question. But okay, I mean, to the extent that you have documents from another court that you want to put into evidence, get certified copies. And if they're relevant, the judge they're self-authenticating on that basis, and the judge should accept them. Now, if you're asking, part of the question was how to use it to demonstrate prior or inconsistent statements?
Well, actually, what is the best way to lay a foundation for evidence from another court? So it's more of a...
Well, okay, if you just want to offer it into evidence as evidence in chief, I would get it all certified, and the judge has to take it on that basis. There's a whole process that you go through if you're dealing with a prior inconsistent statement, and you have to remind them of what they said, set it up, and ask them if you remember being at a deposition where you asked the following question, gave the following answer, yes, and then, didn't you say this, that, and the other thing? And then if it's a prior inconsistent statement, it should be received limited to the issue of credibility of the witness, not as evidence in chief. Best thing is just get the thing certified if you want to put it in evidence.
Okay, great. Thank you.
I just wanted to ask about in-camera interviews with children. Do you have a position on when that is or isn't appropriate in or a custody and visitation case?
Well, certainly they have to be old enough to articulate something. I mean, where that is, I don't know. It's discretionary with the judge. The process, the ability to interview children goes way back to a time before which forensic assessments played such a more prominent role in deciding custody litigation. The theory, as I understand it, is that the judge was the wise, compassionate, parent who was going to interview the child and find out what's going on. It was the case authorizing this process is Lincoln versus Lincoln, decided by the Court of Appeals, I think, in the 60s. I never thought I was certainly never trained to interview children by anybody. I don't hold a degree in social work or psychology. I thought it was difficult. And I always had trouble trying to sort out why I thought kids were saying what they were saying. But there's some law that says you don't have to if you think it might be distressing to the child to bring the child in. But most of the time it can't hurt, and it's judge specific. And if I was asked to do it, I'd raise the issue, and if everybody wanted me to do it, I would do it.
Thanks. Great. So just one or two questions relating to financial support in the family court, because we want to just touch holistically on every area of the family court to the extent that we can. So under the new maintenance laws and spousal support laws, have you, practically speaking, have had any success with that statute? Is it effective?
Well, I actually testified before the Law Revision Commission before the second, in between the temporary statute and the permanent statute, and they did give up enhanced earning capacity in consideration for which they got the present maintenance statutes. So I think the idea was that it was probably more beneficial for lower income, mainly spouses than it was for higher income spouses. But yeah, I mean, my firm has had cases in family court where we sought spousal maintenance, and we're successful doing it.
Right.
So I mean, look, the more, some people would argue that to the extent there's a formula, you're not paying attention to the details of the case. But I think formulas are helpful. I think the idea that there is going to be maintenance and here's how long and here's how much is helpful given the history of typically how women were treated and got virtually nothing. So I think it's a positive step.
Great, great. And have you ever had a case where there's been a long history of non-payment by the non-custodial parent, where you've sought incarceration and have been successful in asking for incarceration as a remedy?
Yeah, look, it has to be really egregious for a judge to lock somebody up. And I could count on one hand how many times that I actually did lock somebody up for non-support. And I think with only one exception, before they left the lockup in the courthouse, money came from somewhere. I don't know where it was from, but somebody came down with some money and paid off, the payee. So, so I don't know. So tell me again, what was it?
It's just how long of a history of non-payment would?
It's got to be a long time, and it's got to be really egregious, and then you may get a judge to do it. The hearing examiner, the support magistrate is supposed to make the findings. Judge is supposed to confirm them and lock up the person for up to 6 months.
And have you ever seen a support magistrate take into account illegal income? For instance, drug dealing, gambling, things like that, or where the court has relied upon that income as a source for the respondent?
I've had experience with that. I mean, income is income, but the issue is how do you prove it? If the guy's a drug dealer, you're not going to prove it except maybe through his admissions. I don't know.
How has the support magistrate dealt with that issue, if you recall?
I think they're uncomfortable because the proof is usually pretty sketchy. And they may just say, look, there's not enough evidence here for me to conclude that this is what the income is, knowing full well that there is income. Or some are stronger than others. If there's no disclosure, they can make findings based on need as opposed to the CSSA formula. There's a lot of different options. So that might be the way to go. If you can't prove it, and if he doesn't honestly disclose what he's got, argue that the support order should be based on the children's needs.
Okay. I mean, are there certain factors that might cause a support magistrate to reject a settlement that's outside of or deviates from the CSSA, the Child Support Standards Act? Are there some?
My experience is that if you articulate something, they're going to accept it. That's my experience, at least.
Okay, great.
Thank you have to say why you're departing from the, you see this in marital separation agreements all the time. They come up with something.
When would a support magistrate reject that something that you've come up with?
My experience is that if you say virtually anything, they're going to approve it. That's just my experience.
Okay.
Prima facie.
Yeah.
I'm paying for this, he's paying for that. I don't know. Therefore, we've come to the following, agreement. I say virtually all the time it's probably going to be approved. Now, I could be wrong. I mean, there are support magistrates that may step in and say this really doesn't pass muster under the statute. I'm not going to do it.
Okay, great. Are there any questions from the floor regarding child support? I know we are very over time, but I wanted to take some questions if there were any, either through the web or no?